Hello, hello, and welcome to Crime in Court. My name is Heather, and we are doing a short, hopefully brief, update on the Karen Reed and Turtleboy hearings. They both were scheduled to have hearings yesterday, which was Monday, February 26th. So we learned a lot from yesterday and what happened. So I have a lot of quick little updates that we gotta squeezed in here, I should say. So up first, Turtleboy was supposed to have his hearing in the morning. He did arrive to court. However, his hearing was canceled, and they were told, him and his lawyer were told, that they were going to be dropping the A and B charges against him, the false charges against him from an angry ex fling that seems to be trying to ruin him. The stay away orders have been lifted, and everything regarding the witness intimidation, he's free to speak to the witnesses again, ask them questions, all that stuff. However, the restraining order that this person, Lindsay, has against Turtleboy still stands because they haven't been able to get that removed or whatever. Not like they even need to, because he wants nothing to do with her, but she has the power then to walk into the courtroom when he's already in there and say, look, I have my court order that he can't be within so many feet of me. And that's exactly what she did yesterday. So that just goes to show how childish and immature these people are. She showed up with Jen McCabe and the Alberts, the McCabes. She showed up with them and had her restraining order in hand, just to show the bailiff so that they could kick Aiden out of the courtroom, which I'm sure they were just so excited to do. Like, how childish and immature are you? But whatever. She never went to any of the other court hearings, by the way. That's what he said. But anyways, let's talk about those A and B charges that she claimed he pushed her on the couch. They're dropping these charges, and I'm going to let Aiden tell you a little bit more about it. I have a short little clip from from yesterday. He made an announcement.
Let's go. Justice is coming. Justice is coming, baby. Justice is coming. Thank you, sir. Thank you, everybody, for coming. I appreciate that. Nice to see so many faces today. Nice to see so many faces. Absolutely. Nice to see you. Hey, nice to see you guys, too. If you guys missed it today, the charges against me were dropped in Dedham District Court. You saw battery charges. It was all a lie from the beginning. They knew it was a lie. They knew that it had a 0.0% chance of going to trial, of even having any chance of conviction whatsoever. They knew that the whole thing was a setup. They knew that if they put this lying complainant on the stand, that their whole case in this court would fall apart. And they didn't want any of that on the record. So they dropped it today, and all they wanted to do was revoke my bail with a made-up charge so they could put me in jail for 60 days and shut me up, but it didn't work because I'm back, and we're 3 days out. They waited 3 freaking days for me to get out of jail before they decided to drop these bogus charges. They knew it was a joke. They knew it was made up. They knew this was all a lie, and they did it anyway because they're corrupt. Well, today is Karen Reed's birthday, and we're off to a great start this morning, and we're going to even have a better afternoon in there. We all saw David Yannetti's tweet yesterday, didn't we? We all saw that tweet with the Teddy Roosevelt quote about the man in the arena. And we saw how he ended it with the 3 words, justice is coming. And that's what I said about a month ago when I was being taken out in shackles in that courthouse over there. And I don't think that's a coincidence. I don't think that's a coincidence that David Yannetti tweeted that out. Because they know something. Something's going to happen today. I have a great feeling. Something's going to happen today. And I can't wait to see what it is in that courtroom. I can't wait to see what happens at 2 o'clock in there. Because this charade is going to come to an end one way or another. Karen Reed's not going to jail. I'm not going to jail. No one's being convicted except the people that murdered John O'Keefe and covered it all up. And the bad guys need to be held responsible. The bad guys. So, well, I appreciate everybody coming out here today. No bullhorn today. That's okay. But, man, it's a nice day for February, huh? This is beautiful blue skies. Happy birthday, Karen. Happy birthday, Karen. Happy birthday to Karen.
All right. So that was just a brief little clip from yesterday. He made a couple of announcements. He made one in the beginning of the day after his court date had been canceled, and then he came back to the courthouse around 2, or before 2, because that's when Karen's hearing was. So he made that announcement on the courthouse steps later in the afternoon. So that was more after they had confirmed that Turtleboy's charges would be dropped. So that's good news for him. It seems like there might be good news on the horizon for Karen, but we didn't necessarily get there yesterday, but I think it's on the way. So let's actually... on the screen in front of you, you'll see the tweet from David Yannetti, or the X. I don't know. Do you call it an X? So this is what he had said the day before. So this was 11:29 a.m., February 25th, 2024. So the day before the hearing with Karen. And this is what it says. So this is Teddy Roosevelt. It is not the critic who counts, not the man who points out how the strong man stumbles, or where the doer of deeds could have done them better. The credit belongs to the man who is actually in the arena, whose face is marred by dust and sweat and blood, who strives valiantly, who errs, who comes short again and again, because there is no effort without error and shortcoming. But who does actually strive to do the deeds? Who knows great enthusiasms, the great devotions? Who spreads himself in a worthy cause? Who at the best knows in the end the triumph of high achievement? And who at the worst, if he fails, at least fails while daring greatly, so that his place shall never be with those cold and timid souls who neither know victory nor defeat. I think that's a pretty appropriate quote. And at the very end, he added, "We are in the arena. The triumph of a high achievement is coming. Justice is coming." So I think that's a little cryptic message there from David Yannetti, letting us know that we're going to be seeing some things happening. Maybe not, immediately, but we're going to see them happening. I know we've all been waiting. I haven't been all that patient, but I'm trying to patiently wait for information from the feds, which now we know has been delivered to both sides. So through this hearing, I'm going to play the entire hearing. I cut out the very beginning where they all announce themselves and some dead air time. So I edited it down just for brevity's sake, but we're going to watch it in a second. I can't remember what I was going to say about that, or what I was talking about. So anyways, I'm going to play it for you, and we're going to talk, we'll talk about it in a second. Totally forgot what I was saying. Oh, before I forget, the breathing in this mic is not me, it is Judge Canoni. FYI, I think, because she's the only one. Well, it could be prosecution, but probably Judge Canoni. It's not me.
Yeah, no, this is all the dates that we're moving. You move to continue, and these are the dates we're having. Do you want me to say them again, Mr. Jackson? No. So on March 22nd, all motions in limine must be filed. On March 28th at 9 o'clock in the morning, we'll have a hearing on those motions in limine. On April 12th, there'll be a final trial conference at 9 a.m. And on April 16th, the jury trial will begin. So it's a 5-week continuance of this jury trial. So I'll hear you.
I appreciate that, Your Honor. Thank you for hearing me on the issue of scheduling. I just want to bring to the court's attention a couple of things. I appreciate the court accommodating us in terms of the motion to dismiss today. I was prepared to argue the motion to continue on that issue, unprepared to argue substantively the motion to dismiss.
We're not.
I understand that, but for the following reason. We received 3,074 pages, 1.3 gigabytes of data. We've only had a chance to go through a smattering of that data so far, right? So a couple of transcripts, we've reviewed and looked at or put our eyeballs on the files, but not the substantive data contained within those files. And I would dare say that the Commonwealth is in the exact same position. There's been an additional TUI request by the Commonwealth that the court is probably not aware of. That came in on Friday. Ms. McLaughlin asked the U.S. Attorney's Office, pursuant to TUI, which is exactly the same protocol that we utilized to get these almost 3,100 pages of data. And so we're expecting that to be heard at some point through the U.S. Attorney's system. In other words, they're going to have to go to the magistrate, deal with the TUI system the same way that it took place here. And that takes not days, but weeks, I expect. We also haven't finished the Bodie protocol, which is the state's protocol with the crime lab, that you're well aware of. I say that to say, through 2 years of litigation with the Commonwealth, just about 2 years of litigation, we've received a little over 3,200 pages of data. In one day, the defense was given 3,100 pages of data, and none of it appears to be duplicative. All of it is brand new, and all of it, Your Honor, appears to us to be exculpatory. The schedule that the court has suggested, although I'm mindful of moving this along, I can't do it in violation of my client's due process rights. I can tell the court there is no possible way that we'll be ready for, just to grab my notes, there will be no possible way that we could have all of our motions written on this issue alone, just the motion to dismiss, by March 6th. That's
So
what
I need you to do is put in writing why.
Sure.
All right.
I can tell.
I am very mindful, though, where the U.S. Attorney says we expect, of course, that the parties will disclose orally the materials in court only as necessary to further the proceedings. So put something in writing, get it to me by this time next week as to why you cannot be ready specifically. But I'd urge you to use that time getting ready. All right?
May I have just a moment to confer with
Yes.
counsel? Your Honor, thank you for accommodating that quick chat. I want to make sure that the court understands that in addition to, and that's what Mr. Yannetti was just urging me to bring to the court's attention, I don't want to speak for him, he can speak for himself. There is a motion to disqualify, which is also robust in scope and terms. He's going to be arguing that. That is yet to be on calendar, and he just indicated to me he does not believe there's any way that he could be ready on this briefing schedule for this kind of influx and incorporation of this level of data.
So you can put that in writing as well, Mr. Yannetti.
That's fine.
I just want to put a sort of a precursor to the court. We expect additional rules based on what we've got so far, and I'm happy to describe a sampling of it if the court wishes. But based on what we've gotten so far over the last 48 business hours or so, there's going to be additional Rule 17 motions, significant additional Rule 17 motions. There's going to be additional Rule 14 motions. We're going to have to supplement the motion for disqualification that Mr. Yannetti just alluded to. We're going to need to supplement the motion to dismiss, which I'm alluding to. We will be filing a motion for extraordinary governmental misconduct based on certain evidence that we just received. And all of this has to predate any reasonable effort that we have to prepare for trial. So my suggestion, and we'll put it all in writing, as the court suggested, but I can tell the court that based on what I know, and I know that the court is operating a little bit in the blind because you don't know what we know, what we have. An April 16 jury trial date is probably not realistic, but I will put all of that, as the court has directed me to, we'll put all of that in writing, and we will suggest what we think is a reasonable trial schedule and briefing schedule based on what we've just received.
Okay. So I need that by next Monday at the latest, okay? Ms. McLaughlin.
A week from today, yes.
If I may, the Commonwealth has had the opportunity to go through all the discovery that's been provided. It is voluminous. It is there's a lot of material there. However, the Commonwealth would dispute counsel's representation that the material is new information. I would say approximately 90% to 95% of the material that we received is consistent with the Commonwealth's theory of the case and the testimony that went to the grand jury of witnesses' statements. There is some new information that counsel will use in their motion, and the Commonwealth understands that. However, I would say the evidence as a whole is very consistent with prior statements made by witnesses that testified for the Commonwealth. Thank you.
All right. All right. So put it in an affidavit by next Monday, but these days, as of now, these are our dates. Okay?
I want to make sure I got the dates, all the dates that the court indicated. March 6th for the motion to dismiss.
To file any supplemental memos on the motion to dismiss and the motion for sanctions, disqualification of the district attorney's office.
The next date, March 22 for all motions in limine.
Yes, for filing all motions.
March 28th for hearing on all motions in limine.
Yes.
April 12th, last readiness conference at 9 a.m.
Yes.
And April 16 for jury trial.
Yes. Okay.
Your Honor, if I may, I may not have heard. The March 12th date, was that 9 a.m. or 2 p.m.?
March 12th, we can go at 9 o'clock and we can take all day. So, all right?
Your Honor, what are the dates for the Rule 17s that we anticipate filing, which we expect are going to be voluminous?
Why don't we do those on March 12th as well?
Okay, Your Honor, we have the calendar for the suggestion we'll file our papers by Monday.
Great. We'll see you on the 12th. Thank you.
All right. So that was basically the hearing. You got all the important bits. So let's go over what those important bits were. Basically, what came out of that was, what I took of that was that the feds did their data drop for both sides, and they are now going through 3,100 pages of data. Within the last 48 hours, they just received it. So they are very busy looking through a lot of papers, a lot of documents, a lot of attachments, a lot of things to sort through and make sense of, and how it relates to what you already know of the case. So there's a lot that they need to do, the defense. As you can see, there were a lot of things that she was going through. The schedule, those were all dates that they have things to reply to or that are due to argue for in court. So they have a lot still on their plate. What we do know about this data, according to Alan Jackson, is that it is not duplicative of what they've already received. So a lot of the data, the majority of the data, is new to them. It's new evidence that they're seeing about this investigation into the investigation of the unaliving of John O'Keefe. This is all new stuff. And with that, it comes exculpatory evidence, and meaning basically that it proves that Karen didn't do it, but they may also have evidence to show that somebody else did do it. So that would definitely exculpate her as well, if they have evidence to show that it was somebody else who ended John's life, which we all know based on the evidence that is the case. All right, so aside from that, we have this big data drop now, and according to that, after, just from their initial preview of it, Jackson already knows that they're going to be filing additional Rule 17 motions and additional Rule 14 motions. So that means they've already filed motions on these topics and are doing it again, or supplementing those past motions, or, because it's based on new information. So they can resubmit, I guess, a filing for that. So let's look at what actually Criminal Procedure 17 is. So let me get rid of the Unetti tweet. All right, so let's zoom in. This is off of mass.gov's webpage. I'm looking the official website of the Commonwealth of Massachusetts, Criminal Procedure Rule 17, summonses for witnesses. So basically, I think this is the portion where it really relates to the Karen Reed case, because a lot of this has to do with the witness summonses and, if they're able to pay and things like that. So this is not, that's not necessarily what they're concerned about. I really think it's right here for production of documentary evidence and of objects. So they don't have documented evidence for things because I think that law enforcement failed to do so. So let's read what this says. A summons may also command the person to whom it is directed to produce the books, papers, documents, or other objects designated therein. The court on motion may quash or modify the summons if compliance would be unreasonable or oppressive, or if the summons is being used to subvert the provisions of Rule 14, which we will read in a second. And that has to do with discovery issues as well. So that's what we'll go over, what prosecution is actually required to hand over as discoverable in a criminal case. So the court may direct that books, papers, documents, or objects designated in the summons be produced before the court within a reasonable time prior to the trial or prior to the time when they are to be offered in evidence, and may upon their production permit the books, papers, documents, objects, or portions thereof to be inspected and copied by the parties and their attorneys if authorized by law. So if things are authorized to be discoverable, the defense team needs to see it. So Alan Jackson's official words were significant additional Rule 17 motions, which means they really significantly dropped the ball in obtaining documented evidence for their case and from specific witnesses in this case. I think that's what this is relating to. I might be speculating, but that's kind of where I'm leaning based on these statutes or rules. So additional Rule 14 motions would be regarding procedures for discovery. So this is Criminal Procedure Rule 14, pre-trial discovery. So this is discovery that goes to the defense before trial. You need to hand this over, prosecution. So automatic discovery. This is mandatory discovery that must be handed over to the defendant. So the prosecution shall disclose to the defense and permit the defense to discover, inspect, and copy each of the following items and information at or prior to the pretrial conference, provided it is relevant to the case and is in the possession, custody, or control of the prosecutor, persons under the prosecutor's direction and control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in the case. So that is saying not just the prosecutor, but anyone in the prosecutor's office, people working under the prosecutor's direction. So if they hire some like independent agent to go out and interview people, that is somebody that, that discovery is also mandatory. Let's see what else. They also mentioned and any persons who have participated in investigating or evaluating the case. So that includes expert witnesses that have looked through police reports and certain files and things of that nature, and also your investigators, your actual investigators that might even be called as witnesses to the case. So all of that information, their reports, all of it is discoverable. And let's see. What of those? What documents specifically from those individuals are discoverable? 1. Any written or recorded statements and the substance of any oral arguments made by the defendant or a co-defendant. 2. The grand jury minutes and the written or recorded statements of a person who has testified before a grand jury. 3. Any facts of any exculpatory nature, and we know from what Alan Jackson said, there is exculpatory evidence within the 3,100 pages or whatever documents that they actually received just recently from the feds. So number 4, the names, addresses, and dates of birth of the Commonwealth's prospective witnesses other than law enforcement witnesses. So anyone that is not within law enforcement, you need to give us your witness list. The Commonwealth shall also provide this information to the probation department. Number 5, the names and business addresses of prospective law enforcement witnesses. So not just the non-law enforcement, but the law enforcement witnesses as well. Intended expert opinion evidence other than evidence that pertains to the defendant's criminal responsibility and is subject to subdivision B2. Such discovery shall include the identity, curriculum vitae, and list of publications of each intended expert witness and all reports prepared by the expert that pertain to the case. So any reports by any expert witnesses is discoverable. Even just a written opinion or whatnot, all that evidence, statements from expert witnesses that's discoverable. All right, so what are we on? Seven? Material and relevant police reports, photographs, tangible objects, all intended exhibits, reports of physical examinations of any person or of scientific tests or experiments, and statements of persons that the party intends to call as witnesses. So all of that is relevant. All of that is discoverable. Number 8, a summary of identification procedures and all statements made in the presence of or by an identifying witness that are relevant to the issue of identity or to the fairness of accuracy of the identification procedures. And 9, disclosure of all promises, rewards, or inducements made to witnesses that the party intends to present at trial. So if you have any witnesses that you are going to present, if you're paying them, we need to know what you're paying them, basically, is what that says. So I think that is the main portion that we need to be focusing on for these 14 motion filings that Alan Jackson said he's going to be putting forth, because we know there was a grand jury, and we know that the Commonwealth hasn't been handing things over. I wonder if they've had the grand jury minutes for a while and haven't turned them over. And it could be any one of these things, I think, or a combination of many of them that the Commonwealth failed to do because they're trying to hide something, in my opinion. That's my opinion. All right, so we know that they're going to do these 17 motions, these 14 motions. What else? He mentioned that they will need to supplement the motion for disqualification. So we read through that. And now with the new information that they got from the feds, they're going to have to add to it. Same thing with their motion to dismiss the indictments altogether. Just here's why you should dismiss the charges, because this whole investigation was phony and a cover-up. So they have to add to that too. They need to supplement that motion, the motion to dismiss. And now they will also be filing a motion for extraordinary governmental misconduct. Those are the exact words Alan Jackson quoted, extraordinary governmental misconduct. So that goes, in my opinion, far, far beyond just prosecutorial misconduct. This is it goes up to the DA's office. It goes up. This is, multiple people had some kind of say in this. And I can't remember what I was listening to, but it was somebody that was saying it doesn't take a whole police department to create a conspiracy. It really only takes a few key players. And I've been saying this from the beginning, when all this Delphi stuff and this Canton stuff and everything, it just, when you start looking at people and going corruption, everybody's like, oh, you're just a conspiracy theorist. But no, corruption happens all the time, and especially in these small towns. And this is why we need to shine a light on what these towns are doing, because they've been getting away with it for so long. And that's why this is important. That's why all eyes should be on this case. It is a very important case. It is, it's huge for the First Amendment, for many of our amendment rights, because they violated a lot of due process for Karen and for Turtleboy, and it's just been it's been bad. So we're waiting for the good. And you know what? Karen Reed and David Yannetti and Alan Jackson, they all walked in so proud, smiles, and they look happy. They know something. That's what Turtleboy was saying too in his courtroom or court step speech, that they know something's up. There's a different vibe in the air. It was just good positive energy that was there. You can go back and watch Tom CPU and some of the other channels stream, but he streams live while he's there, and I always like to check in on his streams on court days. They're great. So anyways, I want to leave you at that. That's pretty much what happened for the hearing. We've been given a 5-week continuance. The jury trial is now moved to April 16th, and that's probably still not enough time given the amount of information that they've received, both sides. And the Commonwealth, by the way, I just want to point out something that the Commonwealth said, oh, we've had a chance to look through all the discovery. How did you have a chance to look through over 3,000 pages of discovery in 48 hours? There is no humanly possible way. I'm sorry, but no, you're lying. But she said, we've looked through it all, and it doesn't, it's consistent with our theories. What? No. Sit down. And notice how Adam Lawley didn't say anything. I think they all feel the heat. Ken Mello was not at Turtleboy's hearing when they let him out of jail and released him. Faking sick. I assume he said he was out ill. So I think it's really coming down on them, and they're starting to feel the pressure. So in a way, that's really good, because we can't have our organizations that we put in place to serve and protect us to be harming us instead and causing fear in our societies. It's just not the way it's supposed to be. That's why we're here. That's why we created America. So on that note, thank you so much for watching. I will be actually updating you guys in another video. We're going to read through the Commonwealth's opposition to the defendant's motion to dismiss indictments and memorandum thereof. So we're going to read through that, what their reasons are. Basically, they're stating that the grand jury said she's guilty, so you shouldn't dismiss the charges, basically. So we're going to go through that in a different video. I just wanted to keep this update of all the court hearings separate, and I will see you soon. Thanks so much. Don't forget to like, comment, subscribe, and take care. Thanks for watching.